Priya Sharma landed in Canada as a permanent resident in 2022. Shortly before her flight from India, she married her longtime partner Arjun Patel. In her rush and confusion, and believing it best for her application, she did not declare her new marital status to the IRCC authorities. 2 years later, established in London, Ontario, Priya was ready to sponsor her husband so they could finally start their married life together in Canada. Worried and unsure after reading online about possible bans for not declaring a spouse, Priya and Arjun contacted several lawyers, attorneys, and RCICs, which led them to Moving Life Immigration, where they sought advice from their renowned legal counsel and regulated Canadian immigration expert, Mirza Azma Azim. Hi Mirza, thank you for taking the time to discuss the situation and possible remedies to avoid any unfavorable outcome for spousal sponsorship. Could you please share the first thing Priya should know about her situation?
Thank you for having me today, Samuel. Well, to answer your question, I'd say that Priya's main issue is that by not declaring Arjun as her spouse before landing, she may have triggered a regulation that can permanently bar her from sponsoring him under Canadian law.
Which regulation is this?
It is Section 117, Sub 9, Sub D of the Immigration and Refugee Protection Regulations, which says anyone who is not declared and examined as a family member before the principal applicant landed cannot be sponsored later.
Why is the government so strict about this?
The government's goal is to prevent immigration fraud, such as people hiding family members to bring them in later outside the proper process.
Can Priya still sponsor Arjun?
Generally, the law is very clear. Undisclosed spouses are excluded. However, she may apply for permanent residence under other programs or seek relief on humanitarian and compassionate grounds, but these are exceptions.
What happens if she tries to sponsor him anyway?
The sponsorship application will likely be refused, and both Priya and Arjun would face a lengthy separation.
If she is refused, can she appeal the decision?
She can seek judicial review of the refusal at the federal court, but courts usually uphold the regulation unless there are exceptional circumstances.
Are there any exceptions where IRCC might be lenient?
Exceptions are rare, but sometimes if there was a lack of understanding, language barriers, or incomplete advice and significant hardship, humanitarian and compassionate considerations might be argued.
What do humanitarian and compassionate grounds mean?
H&C grounds allow the IRCC to consider the hardship Priya and Arjun would face if separated, or if Arjun cannot enter Canada, especially if children are involved.
Does it matter that Priya and Arjun are genuinely married?
Sadly, even a genuine marriage does not change the regulation. The problem is the non-disclosure, not the genuineness.
What practical steps should Priya take now?
She should gather evidence, documents, and proof about her situation, as well as her relationship, and consider legal options, including an H&C application.
Could Priya lose her permanent residency or be deported?
Not for this non-disclosure alone, unless there was more serious or fraudulent misrepresentation.
What if Priya applies for citizenship? Do you know if this issue will come up?
If discovered, it might be questioned, but unless there is a pattern of fraud, her citizenship eligibility should not be directly affected.
Are there any similar famous cases?
Yes, the De La Fuente versus Canada Supreme Court case set the precedent for this very issue.
Does changing legal representation or hiring a new lawyer make a difference?
It's wise to consult an experienced RCIC or immigration lawyer, but the rules apply uniformly. A capable and educated legal counsel can only help present the best possible case.
If Priya had declared Arjun but not completed his medical, would the result be the same?
Possibly not. If she had declared her spouse but failed to follow up with medicals, remedies are sometimes available. However, non-disclosure at the time of filing is most critical in these exclusions.
Could moving to a different province help?
No, immigration rules are federal and apply across all provinces.
Can Arjun visit Canada as a tourist instead?
He can apply, but his prior sponsorship refusal and marital status may cause the IRCC to be suspicious and deny his visit visa.
Is there a waiting period before they can try again to sponsor the spouse?
I'm afraid not. No, this exclusion is considered permanent under current regulations.
If Arjun had children with Priya, would that have any effect?
The presence of children and family hardship might strengthen an agency application after several years, but it does not guarantee success.
Thank you very much for explaining the potential consequences of not declaring a spouse, Mirza. What advice would you give to applicants in general?
Samuel, I couldn't stress more. Always be completely truthful and declare all relationships at every stage of the immigration process to avoid these harsh consequences. Let a licensed immigration law educated and experienced professional steer you through these processes as a guide to represent your submissions lawfully.
Thank you for joining us today. I'm your host, Samuel, and our legal counsel and immigration law expert at Moving Life Immigration Solutions, Mirza Asma Azim. Stay tuned to our YouTube channel for the latest updates and expert insights. Keep sending us your questions by email. We love hearing from you, and we'll answer as many as we can in our upcoming videos. See you next time.